attention to the cost of pharmaceutical technologies and the inequitable access to these. Globally, this has raised questions about the impact of the WTO TRIPS agreement. Presenters in this webinar will cover the aspects of pharmaceutical patents and monopolistic pricing and the shortcomings of these. It will highlight areas of concerns and lessons we need to take forward to ensure equitable access in the future. I'm going to move on to our first presenter. We are very lucky to actually have Tahir Amin join us today. He's an attorney with more than 25 years of experience in intellectual property law. He practiced as a solicitor of the Senior Courts of England and Wales, with two of the leading IP firms in the United Kingdom. And he's also served as an in-house global IP counsel for multinational corporations. In 2004, he left his private legal practice and moved to Bangalore, India, where he was instrumental to the passage of a health-friendly patent law. This process led him to eventually co-found IMAC with the purpose of reshaping intellectual property laws to better serve public interest. He has a number of accolades, team, that I won't read all, but I will definitely put in the chat for you so you get to know Tahir better. I'm going to hand over to you, Tahir. Thank you so much for joining us today.
Thank you, Fatima, and it's a pleasure to be with you. So pharmaceutical drug pricing and monopolies, I think we are all living this, particularly those of you in the global south, as we look at the inequitable vaccine distribution that is happening at this moment. I want to take a step back and really come at it from a lens of where a lot of my organization's work is focused at the moment, but it's relevant to what's happening in South Africa, but also in the global south, because I feel the problems that we have with the monopoly system in pharmaceuticals really does originate from the United States, given the push and the maximalist approach to intellectual property, which, as the sort of abstract for this webinar mentions, is really sort of starts from the World Trade Organization agreement, the trade-related aspects of intellectual property, something that is being heavily discussed these days in Geneva with respect to vaccine access. But just to sort of bring it back to the US, because a lot of people always think that, oh, well, you know, access to medicines is really a global south problem. You know, we've seen the HIV/AIDS crisis. We've seen other issues related to access to TB drugs, hepatitis C. But what's really what people may not really see in the global south, in countries such as South Africa, is that America, the US, one of the richest country in the world, has an immense drug pricing crisis. A 2019 study found that more than 13% of American adults, that's roughly 34 million people, know at least one friend or family member who died in the past 5 years because they could not afford treatment. And that figure is twice as high for people of color. And the same study found that 58 million Americans that experience what we call medication insecurity, you know, the inability to pay for prescribed medication, and at least one time in the past 12 months. So when we look at what's happening in the pharmaceutical space, it's no surprise that we have these stories, because the annual spending on prescription drugs was recently estimated at $457 billion in the US, and that's even adjusting for inflation. And US prescription drug prices have increased by 76% between 2000 and 2017. And it's no coincidence that this increase in prescription drug spending is in track with the increase in patenting activity for pharmaceuticals. If we look at between 2005 and 2015 in the US, pharmaceutical patenting has doubled according to data that is out there. And so when we talk about the monopoly system, it's not just a situation where countries in the global south are struggling to get access to medicines. That is a fact. But also this is a problem that is happening in the global north too. And in the US now, there is an immense debate happening about the role of patents. And one of the things my organizations, along with others, have been really trying to get policymakers here to understand is that one of the key roots of this drug pricing problems lies in the intellectual property system, and particularly the role that patents play. And some of our work has really highlighted how endemic this problem is and how deep-rooted it is. For example, we studied the top 10 selling drugs in the United States, and I think this story is easily applicable to other countries around the world, including South Africa. For example, the top 10 selling drugs, many of which are biologics these days in the United States, we found that there was a total of 1,310 patent applications on these drugs. 692 patents had been granted on these drugs in total. And on average, that's 131 patent applications filed, and that's nearly 70 patents granted on these drugs. And on average, 63% of patents filed on these drugs are after the drug has been approved by the US FDA. So what we're saying there is basically once you've got the main patents, they're still filing several patents after the drug has been approved. And you may be familiar with the term evergreening or life cycle management. So these are the strategies that are getting played out. And the average duration of patent protection covering these top 10 drugs in the United States is 38 years, considering that you get 20 years for an invention, or you're supposed to. So, and in the United States, on average, there's like 2.5 times more patents that are filed in the US than there are in, for example, in Europe. And between 2014 and 2019, on average, we have seen a 71% price increase on these top 10 selling drugs in the United States. So that just paints a picture of the problems we are facing. And when we think about the World Trade Organization, what the TRIPS agreement brought, it really was the beginning of this huge slippery slope that we are on in terms of the power that the pharmaceutical companies have generated through this agreement. I mean, if you think about the sort of neoliberal practices that have happened over the last 40 years, really it was born in the 70s when essentially there was this pushback against sort of this, in the US even, people were skeptical about patents. There was a lot of clamping down on patents. And then in the 70s, there was this push to get IP and intellectual property into the trading system, which was at the behest of Pfizer and the copyright industries. And that was successfully achieved, also with the help of the US government, because then they started to put sanctions on countries in the global south, which then resulted in many of the countries in the global south saying, well, we want to move into a multilateral forum so that we can defend ourselves against these kinds of sanctions. And that's how we ended up with the World Trade Organization, much to the resistance of many countries. India was the last one to resist, but here we are today as we are dealing with this crisis of the pandemic, and access to vaccines are just so scarce. And a lot of it is because of these intellectual property rules. And one of the opportunities, if that's the right word to use in this terrible moment, is that more people have learned about the World Trade Organization and the role that it plays in terms of if you want to say, administrating how these laws play out in different countries and how access is achieved. And I think this is a moment where we may see a sort of change potentially in how we look at these global rules and who they were defined by, and how we actually try to come through this with a better set of rules. That means that the pharmaceutical companies are not gaining more power, but that we are recreating our systems in a more equitable manner. And I'm sure you will hear the term equity being thrown around more and more, particularly here in the United States, given the racial justice that's happening here, and this sort of moment of reflection where the US's history is now coming to bear. But I think we also have to be on guard, because the pharmaceutical industry is going to use COVID as an opportunity to try and actually maximize intellectual property. They're going to use it to justify that, oh, we wouldn't have all these vaccines but for the intellectual property system. And we're already seeing some of this happening in the US, where there are attempts to what we call broaden what is considered patentable subject matter. And I feel my concern is unless the public interest that is trying to prevent this maximizing of intellectual property doesn't stay on guard, we could see further sort of entrenchment of intellectual property rules rather than actually a scaling back, given the experiences that we've encountered during COVID. So what I want to say really is that the pain that countries in the South, global South are feeling, there is also some of that here in the United States. This is not just a global South problem, as the West likes to portray. These rules have also hurt the Americans, Europeans, and we are trying to connect that bridge to say that actually the rules that the West primarily have set up for everybody else are not working even for their own public. And this is a connection that we're trying to make. And so I'm really happy to be here speaking with you, because I think this connection is important for people to understand that this global trading system, the rules of intellectual property, have really caused a dramatic increase in drug pricing problem and patenting. It's kind of telling to think that the US just in May issued its 11th million patent, and it took 155 years for the US Patent and Trademark Office to issue its first 5 million patents in 1991. It's taken less than 1/5 of that time for the USPTO to issue its next 6 million. So this suggests over half the inventions in the history of the US patent system happened in the last 30 years. And have we really become more inventive, or have we just become better at inventing patents? And this really is the issue for me, in terms of how we're seeing language such as innovation just being thrown around. I mean, first of all, the patent system is about invention. Invention and innovation are two very separate concepts. Innovation is more commercializing science that already exists. And I think we're living in a world of the latter, and that's why we're getting more and more patents. And I think it's important, therefore, when we speak about these issues, not to use the framing that the pharmaceutical industry or the protagonists who want to push these protectionist policies. It's important to actually really think about how we use the term innovation. What do we mean by it? Because a lot of drug patents are really just recycled science. I'm not saying that there isn't any utility, but utility is only one factor that you get a patent for. And so these are, I think, things that may sound abstract or philosophical, but I think they're important because language matters. Language actually changes perception. And I feel, as a sort of global access to medicines community, we have done a disservice to ourselves by speaking in the frames of innovation. Because frankly speaking, I think all innovation doesn't deserve a patent. An invention might, innovation is different. And I think this is, to be honest, a very sort of neoliberal language. If you look at the history of Schumpeter and what have you, the whole language of growing the economy was built on this sort of emergence of innovation in the 50s, the scientific revolution. Today, it's very different. It's now just thrown around as a marketing term. So when we're tackling these issues, we need to take some of this language back and reframe it, because otherwise we're just speaking in their terms, and policy people love to just sort of repeat what the industry and those who want to sort of, the financial industry wants to sort of push out there. And I think that's these are the challenges that we face, because this is not just about the pharmaceutical industry. The whole pharmaceutical industry being overly financialized, the financial sector plays a huge role in how it actually shapes their agenda, because we can't blame them entirely for everything. They're just responding to what the market is requiring them to do. So we really have to think about, how do we reshape the current pharmaceutical system? Does it mean that we actually have, where there's a lot of public investment, that there's more of a bigger say in how governments are actually able to utilize the science and inventions that come out of that investment? Because at the moment, certainly in the US and even in other places, as we've seen with COVID, all those sort of spoils go to the private actors. I mean, it's sort of socializing the risk and privatizing the gains. So those are some of my thoughts, and I'm sure my colleagues will have a lot more to add to that and give other perspectives. Thank you.
Thank you so much, Maya, for setting the scene for us in terms of what's happening on a global level as well. And now I'd like to actually ask our expert in South Africa, or activist in South Africa, to join us as well. I'd like to introduce Fatima Hussain, who's a South African human rights lawyer and social justice activist. She's the founder of and heads the newly established Health Justice Initiative in South Africa. She's the former executive director of the Open Society Foundation for South Africa. She has dedicated her professional life to defending and promoting human rights in South Africa, especially in the field of HIV and AIDS, where she worked for the AIDS Law Project and also acted for the Treatment Action Campaign in many of its legal cases. She also hosts special COVID-19 and IP-related podcasts called Access. Fatima, thank you for joining us this afternoon. I do know you have back-to-back engagement, and we really appreciate you being able to be with us today. Thank you.
Hi, okay, thank you, Fatima. You can see the slideshow and... Okay, so you can see the show and you can hear me, right?
Yes, we can.
Okay, great, thanks. And just such an honor to be on this panel with Andy and Yusuf and Tahir, and thanks to Fatima and her team for arranging it. So I just wanted to kind of put what Tahir has said into global context when he talks about the impact of intellectual property and patents on the lack of meaningful access to life-saving technologies. I think that this particular map around the vaccination gap in the world currently around COVID-19, I think is the best illustration of that. And, you know, usually when you show people slides from the IMF, there's a bit more of an appreciation for what is actually happening versus the slides that we show people from Medicin Sans Frontiers or many of the other organizations that are working on access. And the pricing crisis that Tahir has talked about in the US obviously has had a direct impact on how this map actually looks. And it's also had a direct impact on our ability to treat a number of epidemics in South Africa, including HIV/AIDS for the last sort of 2 decades. Because what happens in the US in relation to their pharmaceutical industry and how they protect patent monopolies as well as pharmaceutical monopolies has a direct impact then in South Africa. A lot of the front-runner vaccine companies, but also the companies that produce some of the ARVs or the brand name ARVs or cancer medicines, for example, are also headquartered in the US. And, you know, we'll come to the TRIPS waiver shortly and to the TRIPS agreement and the role of the WTO. And there's a historical relationship between how the WTO was established, how the TRIPS agreement came into effect, basically relying on executives in the US who were part of the pharmaceutical industry. So if you look at just some of the high level figures, and obviously this is up until the end of May, and we update this regularly on a monthly basis, but you're looking at a situation where you have multiple vaccines that could save lives, that are considered safe and effective, that have various levels of registration and approvals around the world, and yet you're still dealing with a pandemic where over 3 million people have already died and the number of cases are increasing. And as we've seen in Africa in the last week, the number of infections are increasing and also hospitalization. In the South African context, we're also in wave 3, and yet the vaccination coverage of the world's population shows a huge disparity between the number of people who are vaccinated in the global north and the number of people who are vaccinated in the global south, and the number of supplies that are available in the global north and the number of supplies available in the global south, which also has, and of course patents, which is one small part of that, and the number of licenses or lack of licenses in order to bring in more supplies into the system through multiple manufacturers. So the HAI has done a FAQ, and I'm not going to read through all of these slides, but the FAQ on the TRIPS agreement and the TRIPS waiver is available on our website. And we basically just wanted to show to you why patents is just basically one part of a number of obstacles that exists in meaningfully managing a pandemic. And in the context of COVID, and it relates to, you know, the waiver request, and Yusuf will take you through on that particular aspect. But copyrights, trademarks, trade secrets, some of the confidential information that are beyond patents are a key part of our ability to actually manage this pandemic in a more meaningful way. So if you look at something like, for example, test kits for COVID-19, or if you look at the vaccines, or if you look at the ventilators, you'll see that a number of measures need to be addressed beyond just patents, and that patents tells you one part of the story. Which is why from the beginning of this pandemic, the People's Vaccine Campaign globally and also in Africa has been saying that the waiver is one part of a three-part process. You also have to share the knowledge, and you also have to ensure that there is technology transfer, because otherwise you're not going to be able to meaningfully address some of the supply constraints and some of the manufacturing constraints. And the fact that like before, like with the HIV/AIDS crisis, what we have seen is a commodification of life-saving technologies. And, you know, basically what underpins the TRIPS agreement also is this notion and idea that medicines and medical products, including vaccines, should be commodified instead of being treated as a public good. So Yusuf will take you through the waiver, but I just wanted to highlight that this is the reason people, you know, there's a lot of confusion out there around whether South Africa and India asked for a waiver proposal just for patents, or whether they'd asked for a waiver proposal on a whole range of elements that make up intellectual property. And you'll notice that the waiver proposal that was submitted in October of 2020 includes a temporary relaxation of the provisions that apply to patents, of course, but also trade secrets, copyrights, and industrial designs, covering all of the technologies and know-how on all COVID-19 related medical products, basically, which are necessary to overcome the pandemic, but for a temporary period until the world can reach population immunity. So what's the situation in South Africa? I mean, I've explained to you why the particular philosophical approach, or basic market approach by governments as well as companies in the EU, in the United Kingdom, in the US, has basically led us to a situation where we still treat medicines and medical products as a commodity instead of a public good. And so the irony is that in the middle of a pandemic such as even COVID-19, you have to look to a trade body to find a solution to issues of meaningful access, which should be underpinned by human rights, as opposed to, for example, finding solutions at the World Health Organization or at a multilateral body like the UN. In South Africa, if we take a step back from what's happening in Geneva, and, you know, if you take a step back from what we think is quite important work being done by the South African and Indian government in relation to the waiver, the irony is that in South Africa, we haven't as yet passed the patent amendment bill, which would make it easier in some respects for South Africa to be able to pursue compulsory licensing measures, which, as you know, and Yusuf has written extensively about this, in 100 years in South Africa's history, there's never been a compulsory license on any pharmaceutical product, despite what we went through in HIV/AIDS, despite what we're going through with COVID, despite the fact that in the last 72 hours, we were told that Johnson & Johnson can't meet immediate supply needs for one of the vaccines that underpins our entire vaccine rollout. We also don't have sufficient pricing transparency, and I think Fatima can speak to that a bit more from your on-the-ground experience. And we don't have pricing transparency because some of the regulations have not yet been passed by the Department of Health. And it doesn't help that in the middle of a pandemic, we also have a minister who's now being placed on suspension. But we have no price regulation for anything that's given Section 21 approval. It's basically exempt from price regulation. That's something that needs to be addressed, and regulations or laws or systems have to be put in place to address that. Our single exit price system, which is the medicines for the private sector, still doesn't have the relevant regulations to deal with global benchmarking. And also there's very little sharing of the input costs. So like Tahir has mentioned, that it takes a lot of effort and energy from civil society groups and activists and patient groups to try and put together the data and the information to show that the risk was socialized, but the gains are actually being privatized. And certainly we've seen that with COVID-19, where a significant amount of public money and investment from the US government, German, UK, philanthropic foundations have all sort of supported the accelerated vaccine research. So of course, the waiver is just one step. I've spoken about why you actually need full technology transfer, knowledge sharing. The tricky part here is that if you have a company that's recalcitrant or refuses, one of the outstanding issues is how do you compel a multinational corporation or a pharmaceutical company that doesn't have a head office in your country, take for example Moderna, to share the technology if there are other companies that have underutilized or untapped capacity who are willing to actually manufacture those vaccines. And I think that is something that we're going to have to work on a bit more going forward. So let me end there, Fatima, and obviously all of the information is available on our website, and you can follow us on all our social media channels for more information. Thank you.
Thank you so much, Fatima. That was really wonderful in terms of the clarity of the presentation and the speed you went through it as well, making sure we got all the information we required. Fatima will be with us for a few more minutes, but she was going to need to leave. But if you have any questions, please put them in the Q&A section, and she can answer them while she's still around. Anybody else with questions for the panelists, we will look at these at the end of the presentation. So please make sure you put the questions in the Q&A. I'd like to hand over to the next panelist that is going to take us through this particular session, and that's Professor Yusuf Fowder. He's a senior research associate in the School of Law. He has been actively involved in community activities for approximately 40 years, providing legal advice and guidance to various community organizations, including civic organizations, political organizations, and professional bodies, and civil society. His research interests lie in clinical law and legal aid service delivery, as well as public health issues, specifically intellectual property and access to medicines. He has taught modules in clinical law, in human rights law, in bioethics law, in human rights, intellectual property, and access to medicines. He's a consultant. He provides technical assistance to a number of countries and regulatory agencies, and we're very happy to have him with us today. So over to you, Professor Fowder.
Thank you, Fatima. Let's see if I can share my screen. Okay, I think you're seeing the wrong one. So are you able to, no. Are you seeing anything of my screen?
We are, but it's kind of very tiny. Yeah, we are.
Okay, so maybe I should just sort of.
Do you want me to share your presentation for you?
Yeah, please, if you could. I think there is.
Yeah, in a second, I'll just get to it now.
Thank you. I think it only allows one presenter to screen share at a time. So if Fatima's presentation is still there, it might be blocking it.
No, it's not there anymore. I'm just opening your presentation so I can share it. And then you must just let me know when to.
Yes, I'll do that.
Okay, so.
Thanks again, Fatima, and warm greetings to everybody on this call. I think that the previous two speakers did a great job of setting the scene. And for me, the big takeaway is, especially from both Tahir and Fatima, is that the intellectual property system is deeply flawed. And that basically what it's doing is creating monopolies which are resulting in this sort of exorbitant pricing, which is felt very strongly both in the global north and particularly in the global south. And Tahir is correct to say that it's not only the global north, but the global south was basically colonized in large part, and a lot of the intellectual property frameworks and so on come from that sort of colonial sort of period. So it's quite obvious that this system is not fit for purpose. It's not serving, particularly depressed and vulnerable communities, and that it needs to be seriously reviewed. And in the sort of context of South, some African scholars are talking about decolonizing intellectual property, and I think that's an interesting concept that we must explore at some point. But coming to the waiver, and you can go to the first slide, the next slide, Fatima. So turning to the waiver, in the scheme of things of this kind of flawed system, the waiver is a very modest proposal. It is not something that's radical. It's entirely within the design of the World Trade Organization TRIPS system. It's asking for a kind of exceptional remedy for very exceptional circumstances that we find ourselves in. So it's actually perfectly within the framework of the Marrakesh Treaty, which formed the World Trade Organization. Waivers have been used before, and this is why it's being placed on the table again. Now, as Fatima alluded to earlier, we had these shortages in the early period of the pandemic, and we had the pharmaceutical companies holding on to their patents and other IP rights and refusing to share their knowledge. And of course, the reason for that is quite obvious, because they're not interested in competition. They're interested in monopoly and maintaining control of the market. So directly as a result of this, in October 2020, South Africa and India, their delegations at the WTO, put forward the proposal for a waiver or a suspension of 4 categories of intellectual property rules, and those are patents, copyrights, industrial designs, and what is known as undisclosed information. Go into a little bit of that if we have time a little later. And what the waiver tries to do is to address this behavior of the pharmaceutical industry, not sharing and not enabling technology transfer, so that more manufacturers can enter the market and to deal with the supply shortages in order to defeat this pandemic. So that's at core what the waiver is about. And if you look at the current situation, this was, of course, before vaccines were on stream. So this was, a couple of months before the first vaccines were approved. Currently, what is estimated is that there's a need for, in the region of 15 billion doses, assuming there's 2 doses for each person, globally. But the best estimates that seem to be around are that, we're likely to get no more than 12 billion doses in this year. And of course, the situation seems to be far less optimistic than that. So 12 billion doses do not translate into 6 billion people being vaccinated, for a simple reason that what we have had is that all the available doses have been snapped up by high-income countries, by the rich countries of the North particularly. And this phenomenon of vaccine nationalism has meant that there's very little to go into those facilities like the COVAX facility, on which most developing and least developed countries depend to be able to vaccinate their populations. So of the 2.3 billion vaccine doses that have been administered roughly about a week ago, up to a week ago, 85% of these have been administered in high and middle countries. And Africa, which I think accounts for about 16% or so of the world's population, has vaccinated less than 2%. So, I mean, that's the scale of the anomaly. And this is the level of vaccine inequity we are witnessing at this moment. Next slide, please. So I'll just quickly recount what was happening at the WTO once this proposal had been tabled. As mentioned, you know that it was asking for a suspension of copyrights, design, and so on, those that are mentioned there, and in particular, things like trade secrets, sharing of regulatory clinical trial data, and so on. That it was in relation to the prevention, containment, and treatment of COVID-19. So important to note, not only a waiver for vaccines, but the full range of technologies and treatments and so on, including diagnostics that would be necessary to deal with the pandemic. And of course, in the earlier iteration of this proposal, the decision was that it should be reviewed within a year and thereafter reviewed annually. So it was fairly open-ended at that level. At that point, a number of mostly developing countries began to join the sponsorship of the proposal. At this stage, there's something like 63 countries which are co-sponsoring, and more than 100 countries which support it. Of course, this proposal is being waived by all the usual suspects, the whole range of those there from the US, UK, and so on. Although there have been some changes more recently with the US signaling that they would support a waiver on vaccines and that they would be happy to have discussions on that. So at the moment, it seems that US and France have come on board. There was a report recently, yesterday, I think, that the G7 is supporting the waiver, but it's very unclear whether they support the waiver in the form that it's been presented, proposed, or whether they support a limited kind of waiver relating to vaccines only. So in the course of these 8 months, there have been a lot of to and fro, and the proponents of the waiver have now devised the proposal to address two concerns that have been raised by the opponents of this here. One is broadening the scope. So it's about all health products and technologies, and this includes materials, components, methods and means of manufacture, and so on. These are very important areas around the manufacture, which won't merely be solved by allowing a license on a patent and so on. And secondly, they address the question of the duration. And now they're talking about a period of 3 years to be reviewed annually. And of course, at the end of the period, they could decide whether the waiver would have served its purpose. At the moment, the main opposition is coming from the European Union. They put forward an alternate proposal. This is clearly a rehash of all the things that have been said previously and tried and not worked, including provisions like Article 31 bis, which was an amendment to TRIPS agreement to allow countries with no or little manufacturing capacity to be able to import from other countries who are manufacturing them in situation where, of course, those countries were barred from supplying more than they had to retain the predominant production for their domestic use. So this is the proposal. This is the kind of proposal that have been is being rehashed by the European Union, has got widespread opposition to it, mainly from sort of civil society. And of course, what the situation is at the moment is that they have agreed to move to what is known as text-based discussions. In other words, to look at the wording of the waiver proposal and to see if consensus can be found. And in terms of the timetable, we're looking at, in a couple of days, informal discussions beginning, and then hopefully in time to be able to come to some consensus and present a report to the General Council on those dates, 21st and 22nd of July. So to the last slide, Fatima. So here I'm just going to focus on a couple of things. And one is, what would the effect of a waiver that is approved be? And secondly, some of the challenges with the present form of the waiver. So it's not fair to say that the waiver is a very slight thing. It is a substantial proposal in terms of the kind of effect it could have. At the moment, if a competitor or a country wants to issue a license or a government use license, a compulsory license or a government use license, it would have to apply for it on a case-by-case basis, for a particular drug in a particular country and so on. What the waiver would do, if approved, is that it would do away with that need for a case-by-case application of licenses and so on. This would act as a kind of blanket suspension of those protections. Secondly, importantly, it provides cover to countries against any action that could be taken against them at the World Trade Organization dispute settlement process. So we know that we've seen in the literature, in the jurisprudence, that every time there's any threat to the strong intellectual property rights that are covered in TRIPS, a country would be hauled to the WTO to say that it's not complying with TRIPS rules and so It also takes the pressure off developing and least developing countries to initiate things, to sort of negotiate for voluntary licenses, which take a long time, or to issue compulsory licenses with all the risks that go with it and all the complexities that go with that. So it does have that particular advantage. However, having said that, there is still a need for countries to what is called domesticate international law. So even though the waiver may be passed, they will have to, either through executive action or through a legislature, pass a law to say that these provisions of the waiver apply here. And as Fatima indicated, in South Africa, there's also the need to pass the long-awaited patent amendments. We had a policy 3 years ago, and there's been absolutely no movement on that. So that would still need to be done. So then turning to the challenges, even though the waiver has some very positive elements to it, I think there's some significant risks there. The obvious one is the negotiations being protracted, equitable access continuing to be elusive, and more fatalities, more casualties in this pandemic, or that parties would be cornered into a very watered down compromise in the negotiation. And we've seen that happen with the paragraph 6 of the Doha Declaration and how that panned out. So, I mean, the results could be actually fairly meaningless, and that is a huge, huge danger. Secondly, I think as Fatima alluded to, there's no compulsion on intellectual property rights holders to cooperate in IP and knowledge sharing, right? Or engage in technology transfer. I mean, this just says that, they will kind of waive, and they could sit back and do nothing, and, we'll have that issue. So I think that needs to be addressed. High-income countries need to leverage the substantial public investments they've made in vaccine development to begin with, but also in other therapies and diagnostics and so on, to require IP holders to commit to things like the COVID technology access pool, where they can voluntarily give up their licenses, and those can enable manufacturers throughout the world to produce and enter the market. And then finally, it's not clear from this proposal what will happen with those commitments that countries have made in free trade agreements, right? You know that we have a TRIPS agreement, which sets down the minimum standards, right, for intellectual property protection. But in free trade agreements, countries have often committed to higher standards. If the waiver does not address that, we're not sure, whether countries could still be sanctioned in terms of those agreements. They could be taken to courts and arbitration and so on. And the same with bilateral investment treaties, where countries have made commitments in terms of engaging with those industries which have got investments in their country, like pharmaceutical industry, and whether in terms of those agreements, they could still be sued. So there's a lot of gray area and challenges that are still there, and hopefully these will be addressed in the negotiations that go forward. So I'll stop there, and perhaps we can pick up in discussion again. Thank you.
Thank you so much, Prof. Ada. That was really a very good synopsis of what is going on. And I am going to take you up in the discussion about some of these bilateral trade agreements and investment strategies as well. But I would like to now introduce our last panel speaker for today, who's well known to the UKZN community and beyond. This is Andy Gray. He's a pharmacist whose research interests include policy analysis, in particular the development and implementation of the national medicines policies, rational medicine use, and the application of antiretroviral therapy in resource-constrained settings. He's a senior lecturer in the Division of Pharmacology, Discipline of Pharmaceutical Sciences at UKZN. He's also a consultant pharmacist for Caprisa and currently a vice president and fellow of the FIP. He has been a member of the Scheduling and Naming Expert Committee of the South African Medicines Control Council and now SAHPRA since 2000. He's been appointed on the National Essential Medicines List Committee since 2012. He's a member of the World Health Organization's Expert Panel on Drug Policies and Management. There are much more, but I'm not going to go through them, and I'm going to hand over to Andy now for his presentation today. Thank you.
Thanks very much, Fatima. And can you hear me and you can see my slides?
Yes, I can. Thank you.
Okay. So I've got the quite simple task at the end to talk about our Medicines Regulatory Authority, SAHPRA, and IP and how those are linked. So the basic question that I want to ask is, to what extent and how is intellectual property considered by the South African Health Products Regulatory Authority when registering medicines? And I'm going to focus on medicines, not medical devices or in vitro diagnostics. You might say that because it is so important to the regulation of medicines that there would be an explicit coverage of intellectual property in the Medicines and Related Substances Act, which is the act that governs SAHPRA's activities. You might even get a hint in the long title to that act, which says that the act is intended to provide for measures for the supply of more affordable medicines in certain circumstances. But in fact, right up front in the act in section 1.3, you find a prohibition on consideration of cost. So in determining whether or not the registration or availability of a medicine is in the public interest, SAHPRA can have regard only to the safety, the quality, and the therapeutic efficacy of that medicine. So it cannot consider the price of the medicine, the cost to the healthcare system, or for that matter, whether or not it is patent protected. You might say, hang on, but didn't intellectual property get the South African government into trouble way back when the first amendment to the Medicines Act was passed in 1997? And it is true that the Pharmaceutical Manufacturers Association and member companies' 1998 court action targeted primarily a section of the amended act which mentioned the Patents Act. So section 15C is entitled Measures to Ensure Supply of More Affordable Medicines. And it gave the right to the minister under prescribed conditions to enable access to more affordable medicines. And the mechanism appeared at first glance to be related to compulsory licensing. It said, notwithstanding anything to the contrary contained in the Patents Act of 1978, the Minister of Health could determine that the rights with regard to any medicine under a patent granted in the Republic shall not extend to acts in respect of such medicine which has been put onto the market by the owner of the medicine or with his or her consent. So it appeared to be a grab of intellectual property. You need to read this together with two sections that bracket that prohibition on looking at cost. Sections 1.2 and 1.4. 1.2 is quite obscure when read on its own. And it indicates that unless a medicine is registered, even if it is identical to one which is registered, it's not the same. It will not be regarded as being that the same medicine as that other medicine if registration thereof is not applied for. And so that again seems to create a barrier to bringing a follow-on or a generic medicine to market. And then 1.4 says international tendering for medicines shall be allowed in the prescribed manner and on the prescribed conditions. In South African law, prescribed means prescribed by regulation. So we need to go to the general regulations issued by the Minister of Health on the recommendation of SAHPRA to see what is covered there. Regulation 4 deals with international tendering. It says that the state may seek medicines on the international market, but they may not be procured unless they are registered in terms of the Act. So it gives with one hand and it takes away with the other. It makes it very difficult to buy on the international market if those medicines are not registered locally. And then Regulation 5 deals with the importation of medicines contemplated in Section 15C. And after the PMA and its member companies withdrew their court action in 2001, it became apparent that either by initial design or by virtue of an accommodation reached with the pharmaceutical industry, the South African government intended to use Section 15C only to enable parallel importation. In other words, if a medicine sold in the country which is under patent is sold somewhere else at a lower price, that other medicine can be brought into South Africa in parallel with the one which is registered here. But Regulation 1D is again the kicker. The medicine has to be registered in terms of the Act if such a medicine is so declared. And in fact, no parallel importation has occurred since this was brought into effect in 2003. So we're getting close to 20 years later. Nothing has reached the market. And in fact, nothing has been bought on international tender. So does SAPRA consider the patent status of a medicine or its constituents when evaluating an application for registration, either as a new chemical entity or as a generic medicine or a biosimilar medicine? The simple answer is no. No information about patent status is elicited, nor is patent status explicitly considered. But that does not mean that the holder of intellectual property, such as a patent, cannot take action. And I've given you just two examples from our jurisprudence to illustrate that. The first, Bayer versus Pharmacodynamics, this is a case from the Supreme Court of Appeal in Bloemfontein, where the original patent holder was able to prevent the entry into the market of an oral contraceptive and was in fact able to update an existing patent to close any loopholes that might have been used by the generic firm. The second of those cases, Biotech, involved, again, a Supreme Court of Appeal judgment in which the court found that the package insert, what we now call the professional information, the label in American parlance, is a form of intellectual property and belongs to the applicant, not to the regulator. So where a generic firm copies the professional information, it can be found to have breached intellectual property that belongs to that originator manufacturer. A more recent case involves this documentation that was sent to all health professionals on the 24th of May this year. It covers the issue of a generic version of rivaroxaban, an anticoagulant which has been used in COVID patients, that was registered by SAPRA and marketed by Orstel, but the sale of the product has been challenged by the patent holder, Bayer. And the same company has also objected to another generic marketed by Dr. Reddy's. So in other words, even if registration is possible because SAPRA does not consider patent status, that does not mean that sale would not be held up because of the use of the Patents Act. If we look at the guidelines to the SAPRA processes, there are very few mentions in there of anything related to patents. One is, or intellectual property more broadly, one is in the proprietary name guideline, which says that when a particular proprietary name is being considered by SAPRA, the fact that it might be trademarked is not SAPRA's concern, and it is not taken into account during consideration of the acceptability of a proposed proprietary name. But similarly, if SAPRA approves a proprietary name, that does not mean that it constitutes a copyright or a trademark on that, that name, and it cannot be used in trying to support a claim to intellectual property in this regard. South Africa's patent law does include a BOLAR type provision. So in section 69A, it is stated that it is not an act of infringement if someone either imports or makes or prepares a medicine, for example, a patented invention, on a non-commercial scale, purely for the purposes of satisfying a law requiring regulation of that product, such as the Medicines and Related Substances Act. But that cannot be used for any other purposes. So in short, IP status is not considered when accepting an application for registration, nor when deciding on that registration. In addition, SAPRA does not have an explicit policy on data exclusivity. And in fact, data exclusivity is not considered when safety and efficacy data are relied upon. They are not accessed. Again, they are considered to have already been assessed in the innovator application. With biosimilars, the situation is somewhat different because the data requirements are more extensive and have to be provided by the biosimilar applicant, in which case they might run into problems of data exclusivity. The flip side of this is that SAPRA gives no marketing exclusivity to first mover generics, as is common in other jurisdictions, and it cannot use an extension of market exclusivity to promote a desired application like a new pediatric registration, as is done in the US and in Europe. However, as has already been pointed out, South Africa has an IP policy with phase 1 aimed particularly at IP and public health, and specifically at medicines and other health technologies. That was published in 2018 and has yet to be converted into legislation, either in draft form or tabled in Parliament. A few important elements there are the introduction of a substantive search and examination process rather than just a rubber stamping of applications that are made, as well as enhanced patentability criteria and provisions for patent opposition, both pre-grant and post-grant within our intellectual property system. So there's an awful lot that still needs to be done, even if it is not within the remit of SAPRA. There's one more unresolved issue for SAPRA, and that is the issue of transparency. In the WHO global benchmarking tool for national medicines regulatory authorities, there are a number of elements that look to mechanisms to promote transparency, accountability, and communication, to conveying the basis for decisions on which regulatory activities are made, and for publishing summary technical evaluation reports like an OSPAR or an EPAR. And we are beginning to talk about a ZAPAR, a South African ZAPAR, a public assessment report. So in summary, SAPRA generally does not consider IP explicitly, but it remains affected by the antiquated TRIPS Plus nature of South Africa's Patent Act. It aspires to WHO Maturity Level 3 status, but it needs to develop more robust transparency provisions, which take into account modern approaches to commercial in confidence information. And so it's on the one hand wants to stay ignoring IP, but on the other hand has to think about other forms of intellectual property, such as data exclusivity, copyright, and undisclosed information. Thank you very much.
Thank you so much, Andy, and really putting it into perspective about what SAPRA's roles and responsibilities are. But again, that brings the question that there are multiple agencies working on medicines and access to medicines, registration, pricing, IP, and there needs to be some sort of interministerial collaboration between them. What is your take on that before I move to Tahir for his first question as well?
Very much so. And I think the linkages between intellectual property, the regulator, and the issues of selection of medicine, the pricing of medicine, their inclusion in the National Health Insurance Scheme needs a lot more attention. We've seen examples in other countries of access provisions. So, for example, NICE in the UK, the body that's responsible for health technology assessment, has access to MHRA undisclosed documents. It means that some of their reports are redacted, but at least we know that the most complete set of data is used when making decisions around cost effectiveness and selection for the British NHS. That's an example of something we need to do here. But also, when we start to develop the processes for patent examination, I think it would be good to build into that some contact with the regulatory authority, especially when we're trying to determine patentability of something, to understand whether it really is novel, whether it makes the difference that is claimed in the application for patent status.
It's also required for horizon scanning, right? Because you need to know what's going to be coming into South Africa as well in order to be able to then assess any sort of assessment, like HTA assessment in that regard, or willingness to pay, or have a price threshold for the country.
Absolutely, absolutely. And that sort of pharmaceutical intelligence component is very poorly developed in South Africa at the moment and needs a lot of attention.
I'm going to move on. I've got more questions for you, Andy. And while we wait for the audience to please put the participants to please put their questions in the Q&A box. Dahir, in your presentation, you mentioned the issue of a number of patents being applied for after a medicine is marketed as well. And I think you were one of the key ones to also present to Congress lately about the ones that are more than a century old, and that is insulin. So can you tell us a little bit more about those sorts of patents that are being applied for, and the sort of gaming in the system that's going on at a global level?
Yeah, so typically, depending on the technology involved, for example, if we're looking at small molecule products, which are organic compounds, the company will file, or it may not be the company, it may be something that's come from public research or some smaller lab. They will file an initial patent covering the compound or several compounds. And in there, they will probably try and get the broadest level of protection, perhaps saying even that it can be used on a new number of various different indications, that the compound can be useful for that. And then subsequently, that patent is really the sort of the base patent that kind of drives the investment in order to bring a product to market if it's successful. But once it gets approved, then if it's potentially a drug that's going to bring high revenues, then companies will set out a way of actually building on that initial patent, even though the initial patent may already tell you what that particular compound is capable of, how it can be used in relation to different indications. And then they'll tweak it. They'll say, well, they'll give it a formulation, they'll give it a specific dosage. So what we get then is essentially the initial knowledge, what I might call the invention aspect, then falls into the realm of what I call innovation, which is where I think the patent system has got all confused deliberately, because it's a lower bar. And so what you can do then is, particularly in countries like the US, the West, and actually this is becoming more endemic, is the more I do these little tweaks, I can say, oh, well, there's utility. It's not obvious, even though it is pharmaceutically, at least from pharmaceutical knowledge. And so that you're able to build out this thicket of patents. And with respect to your question on insulin, I think there's often a little bit of a misunderstanding, even though insulin is what we have though is these newer insulins as synthetic insulins, as opposed to the more sort of animal-made or human-made insulins. And for better or for worse, the patent systems now allow taking something out of its natural state, and if you sort of tweak with it in a kind of a human way, you're able to get a patent. That's another discussion. Should that be allowed, especially when we think about the increased patenting activity happening around cannabis, or happening around psychedelics, taking something in a natural and being able to sort of tweak it into a with some kind of human input that gives you a patent these days. Those are policy questions that we need to think about. I know there's a lot of work happening in this sort of psychedelic space where people are concerned about the patenting activity that's increasing, but this has happened since the 80s, ever since there's a case in the US called Diamond and Chakrabarti, where basically anything that involves some human element is patentable. And I think we've kind of gone down that road further and further. And just on that point of how these patents get filled out, it's like for every indication that I might do a clinical trial on. So if we take a drug like Humira, which is for rheumatoid arthritis, but has over, at least in the US, 11 different approved indications. I've already told people that I know I can use this on all these other indications and even maybe claim some of these indications in the initial patent, but then I can subsequently start getting patents for those other indications in different ways. And that, I think, is a significant problem, why we see more and more patents emerging. But the vehicle that's driving all that is this idea of economic growth and sort of this what I call this cult of innovation. We've got so sucked into this idea that everything's new and it's better, even though the initial science has already told you that it's possible. And I think largely it's by design. It's to create longer monopolies, is to actually keep you a life cycle management of an existing product longer than it should be.
That's actually very true. And I think we need to be careful also about the term innovative and what it actually means. And it becomes more critical about the patent system when you talk about traditional medicines in African countries as well, and how they will then fall under this whole patent issue. So the South African Patent Act will definitely be testing all of those boundaries as well. Fatima, I know you've put something also in the chat, but I wanted to ask you as well, a lot of the messaging coming out from protagonists that are against the TRIPS waiver and the move towards getting this TRIPS waiver approved is that waiving the TRIPS or having this waiver is not going to actually have any effect because companies cannot be established overnight to produce these medicines. There's the idea about waiving the agreement versus technology transfer, all of those sorts of things are coming out as arguments against the support of this sort of thing. What do you have to say to people who have those sorts of comments to make?
Thanks. Initially it was an opposition to the waiver because the waiver wouldn't make a difference. And then it was opposition to the waiver because the waiver would mean a restriction on patent monopoly rights. And so the levels of opposition we've seen to the waiver, to a temporary relaxation of intellectual property, is quite something. I don't think we've seen this kind of defense and opposition since the height of the HIV/AIDS crisis. But what the waiver would do, and MSF has been really good in trying to simplify the potential impact the waiver could have. And remember, we would be in a very different position if the waiver, which was presented in October of 2020 last year, was agreed to then. It's taken months to get to the process of even now having negotiations around the text. But what the waiver does is that it de-individualizes the need for every country to take action against every particular company. And so and Tyre has said this before in previous interviews, you are able to pursue a set of measures without looking over your shoulders. And Andy's talked about what happened with the PMA case and what happens when armies of lawyers are basically brought by pharmaceutical companies. It also then means that you don't have to take in each country individual action around compulsory licensing. And we've seen how difficult even to invoke a compulsory license in this pandemic it's been in the case of BioLease and Canada, where BioLease has already secured Bolivia as a potential customer, and Johnson & Johnson refuses to give a license to BioLease, which actually has capacity. So let's talk about the capacity arguments. There are companies that are saying currently, if they were to be given the waiver, if there were to be a transfer of technology and an explicit cooperation by the pharmaceutical companies in this pandemic, within months you could scale up some of the manufacturing capacity, particularly for mRNA vaccines. So there's some work done by some of our partner organizations in the US, like Prep for All and Public Citizen, which shows that it would take a matter of months to basically retrofit a facility for mRNA type platforms. And that certainly has happened in Europe where that supply crisis was. So a lot of us feel that a lot of the arguments that are being thrown against the waiver are really disingenuous, but they are deliberately disingenuous because I think there's an ideological fear and an existential threat to the notion of pharmaceutical monopolies and to the notion of commodifying pharmaceutical products using trade rules. Because if you allow this waiver and you allow it in a more easy sort of manner, then you open up, I think, the door to start dealing with a whole range of other medicines and other medical products for other epidemics and pandemics in a similar way. And so I think there's it's basically gets to the gut of the entire pharmaceutical model. And so some of these arguments are also disingenuous in the sense that it's trying to not provide solutions on the table and to try and drag out a process that could actually, give you some measure of relief in relation to managing this pandemic. If you look at the number of licenses given, or the number of licenses voluntarily issued, the full manufacturing licenses, not just fill and finish, and licenses that don't have restrictive terms and conditions, it shows why this waiver is so critical and why it's such an important part of a multi-pronged strategy to try and make sure that IP in all respects doesn't become the key barrier to why you and I are still, or for the reason for why you and I are still waiting for a vaccine, and why many people in the global south are still waiting for a vaccine. Thanks.
Yeah, it's critical as well, Fatima, because there have been a number of companies that have come out even on the social media platform and say, we are available to be able to do the manufacturing and the fill and all of that sort of thing, but none of those offers are being taken up. Basically, there's still very much, and I think Dai mentioned it as a cash cow aspect to this. Everybody's seeing it as a profit margin. It's created billionaires during this time. All these companies that have produced these vaccines have made millions, and they're talking about the fact that the booster shots will now also bring in a whole lot of income as well. I know that Yusuf and Andy have raised their hands. I have a question for Yusuf about the bilateral agreement, but I'll ask him to first respond to this, and then Andy.
Yes, I just wanted to add to the sort of issue of that Fatima alluded to, and that is the whole question of technology transfer, because I think the question of capacity in especially the developing world is closely tied to that issue. We've had provisions in the TRIPS agreement for more than 25 years, and we've had very little movement on that. So they just clearly, it has happened because there's resistance by high-income countries to push their industries in a direction that would enable technology transfer, would enable capacity development, in broadly across the world. It's correct that there's some amount of idle capacity which can be immediately, mobilized to get into vaccine production. Of course, it's complex, complex production processes and so on. But I understand that, for example, Serum Institute was able to roll off its, AstraZeneca vaccine in 4 months between June and October, from the time that they signed the agreement to when that happened. So, of course, Serum is a bit of an exception because it's got a long history of vaccine manufacturing experience and so on. But it points to the fact that it can be done if they're properly supported and capacitated and so on. So.
Thank you for that. Andy?
Yeah, I wanted to touch on the issue of supply security. Access relies on not only the quality, but the reliability of that supply chain. And what worries me is when a narrow set of kind of preferred licensees is repeatedly used by all of the firms, that we run into the potential for that one additional source being compromised. And the Serum Institute of India is a very good example. Novavax has just released its phase 3 data from the US and Mexico, and has indicated that it is licensing SII to make a copy. But that would be subject to the Indian government's ban on exports. So we can't have all our eggs in one basket. A big part of why we want to expand production is not only to ensure volumes, but to ensure redundancy in the system in order to make sure that if something goes wrong in one place, that we can respond from somewhere else.
And that's why I think people like the Medicines Patent, or the organization like the Medicines Patent Pool, is a good initiative as well, because they've now have a portfolio of companies that are inside and outside of India that they can negotiate to do production in terms of technology transfer. And these can also be very much regionally based, so that there's regional resources and regional supply without having to wait for them to come from overseas or some other areas. Fatima, you had your hand raised. So do you want to respond to some of the things that were raised?
No, I mean, I just wanted to caution that, this is the same thing that we saw with HIV/AIDS, that you need multiple supplies in the system to secure your supply streams. And I think South Africa and Africa is experiencing that right now. The Johnson & Johnson saga needs to be written up because it shows you what happens when you have limited suppliers. But voluntary pooling mechanisms, even in this pandemic, have shown not to work. And so I think we really need to have a reckoning with how we deal with multinational pharmaceutical corporations globally, and how we deal with this sort of notion that they are in control and they get to make all the decisions and they decide, bottom line, who lives and who dies, right? And so even with the serum agreement, there are clauses which relate to the preferred customer, and the preferred customer is if you have a supply crisis in the UK, supplies must be diverted to the UK. So this issue of patent monopoly is how we are so deferential to pharmaceutical companies and their CEOs, and how we expect them to voluntarily cooperate, even in this pandemic, with CTAP, and the lack of involvement and explicit cooperation around pooling their technology has basically shown that this model is actually not working. And if this is the model we're going to have to use for the next pandemic and the pandemic after that, or for vaccine access in 3, 4, 5 years' time, then, this is not going to be sustainable, and more people are going to get sick and die.
Thanks, Fatima. Tahir, you had your hand raised. I'll ask you to respond as well.
Yeah, no, I think just jumping on what Fatima has said, it's fascinating or it's actually sort of almost annoying to hear how the European Union, in its counter proposal to the waiver, has said that voluntary mechanisms should be used, when a year ago, when the CTAP was created by WHO, it was kind of poo-pooed, and even Pfizer's CEO was saying that it's absolute nonsense. And now we've gone full circle and saying that actually voluntary mechanisms are the way forward. And we have to understand this in the context of what's happened in the global access to medicines movement. Organizations like the Medicines Patent Pool eventually have done a decent job in increasing access in the global south, but it just didn't happen overnight. And Fatima will be well aware of this. Those of us who were working on this issue when the Medicine Patent Pool was created, and this idea of voluntary arrangements, which was actually a pharmaceutical industry model that was created. It was when Gilead started, when India passed its patent laws in 2005 to be compliant with the TRIPS agreement, realizing that they were going to struggle to get some of their patents granted in India. They came up with this third way that is now talked about, where they would give licenses voluntarily to Indian manufacturers, and essentially it created a divide. It was kind of divide and rule, sort of old colonial tactics. And today, those very Indian companies do not oppose or challenge patents. In fact, they ask for voluntary handouts, and so it's a kind of as a result of the TRIPS agreement that these local manufacturers, rather than upset any commercial arrangements because they're dependent on these deals now, they are now actually supporting these voluntary mechanisms. You can see how the landscape has shifted from where we were fighting IP, resisting these sort of maximalist IP laws into local legislation, to now actually just asking for handouts. And so a lot of revisionism has gone on in terms of what the usefulness of these voluntary mechanisms. And unfortunately, I don't want to be critical here, because and with Fatima, we were pretty critical at the time in 2010 when the MPP emerged as this kind of solution. And there's what the UNITAID body calls an innovative solution. There's that word again, innovative, which I deplore. it's caused all sorts of problems, and we're living in that now, right now, with this COVID. I think actually we need to strip back all these facades of what the voluntary mechanism means, and we really need to get to the root of the problem and real structural changes to the global medicine system, because the voluntary mechanism was just really a stopgap which allowed laws to keep perpetuating and keep getting worse in the darkness. And so even countries like LDCs, where they're implementing IP laws under the sort of the benevolence of these voluntary mechanisms, and it's a disaster.
Thanks, Sahil. No, I agree with you, but I also want to know about this issue of, the fact is that patent looks at innovativeness, but they also don't take into consideration that and I know I hate innovation and the innovativeness word as well because it's been abused so much, but they don't take in the input that's been put by public funding or public resources or public research. And that's also a drawback to the patent system, isn't it?
So the question of whether how public funding is not given its due, is that the question you're asking me?
Yes, because I mean everything gets 20 years, for example, but none of it is sort of said, you know what, half of this is from public funding and public finances, so you can't claim all of these years, for example.
Right. Yeah. No, that's correct. I think we do need to have a better have a system that takes into account where did the actual core science behind a particular product come from? Did it come from public funding? And there's numerous studies out there that suggest that at least a number of drugs that are approved by the US FDA have a lot of public funding that sort of kickstarted it all. And I'm not trying to say that there's no role for the private actor here, because a lot of public funding doesn't necessarily lead to the end product. So there is some involvement that pharmaceutical companies or some skill and level that pharmaceutical companies bring, but we have to look at what's a just and a sort of equitable reward here,
and a reasonable reward, right?
And I think we've certainly just created this system where, like, in order to, again, that word is sort of to push this innovation agenda and investment, because these innovation and investment are two words that come together. I think if you look at the economics of how all this is shaped out in terms of market forces, these words are constantly appearing in that kind of discussion. And so really we're living in this system of the sort of the system that was created by the Milton Friedmans in the 70s, whereby basically all companies are really geared up to do is to make profit. And so you use these words like innovation, and anything that publicly is kind of developed is going into the private hands, and it's all about driving growth and economic growth. So all these pieces that come together, when you hear politicians and policymakers talk about this, it's all part of the same fabric, and we have to get out of that. We have to uncouple all these things, and we really have to start looking at what does the equitable medicine system look like, where you have a lot of public dollars going in, and how then do the rewards transcend to the private actors who do bring something to the table, but they don't bring it all.
Thanks, Zaire. I think that wordplay is very important. I see Andy's hand, but I also think that people should go and have a look at the New York Times front page today, where Pfizer has an ad that says equity. So, there's this learned thing that's coming where you have activists start using these words and then companies turn around and do a wordplay on them. Andy?
Thanks, Fatima. So I wanted to add to Tahir's point about where we create the Band-Aid to deal with the problem. And in South Africa, we've dabbled in the issue of state investment, but we also, in all of our universities, see this as what's called a third stream revenue opportunity. So we drive the very opposite of access. But we have to learn from the American experience with the Bayh-Dole Act and march-in rights, and how difficult it has been for politicians to exercise what the law enabled them to do, and to avoid making the same mistakes again, so that we don't forever have to be sitting with a begging bowl.
I agree. And I think that's the key message from today. I want to end with one last question for any of you to answer, but maybe also Yusuf to lead on because we just have 4 more minutes to go. So, we have these trade agreements, we have these waivers, we have these flexibilities and so forth. And then we have the fair trade agreements and the bilateral investment strategies. And countries use these, and I'm talking about US and European Union more especially, to kind of insist on things that benefit their economy and the companies in their regions as well. And most low and middle income countries do not have the resources to be able to then counter those negotiations as well. So how do we get the message out that there needs to be a health expert or an IP expert or something in the team that's looking at these agreements?
So I'll start and hopefully not take too much time. I hope there were fair trade agreements, Fatima. They're actually free trade, which are neither actually free or fair. So, that out, yeah. So I don't know too much about the free trade agreement, except to say that generally the protections that are usually secured in these free trade agreements are of a higher order. So, they allow for things like extending the patent, the opposite of what you were just saying a moment ago, for additional years and so on, if there's delays in the regulatory process or the approval process and that kind of thing. But let me just touch a bit on the bilateral investment treaties, because I think that seemed to be your concern at the outset. And let me just say that, let me start by saying that there's a trite legal principle which says that if you have a dispute, right, the dispute has to be brought before a forum in usually the place where it happened. If you have a motor accident and you're in Glenwood, so it would be the court in that particular jurisdiction will hear the case. And this is a very trite sort of principle. Now, what has happened in the bilateral investment treaties is that, firstly, they're treaties between countries. But as we know, high-income countries use these mechanisms of FTAs or BIs, as they call them, to secure the interests of their strong industries, right? And that's really what they're doing here. So what they're in effect saying, by putting in particular provisions about dispute resolution, that they want more control over this. And the way they do it is by putting in provisions like the investor to state dispute settlement mechanism, which essentially says that, well, we won't have to use your courts. We don't, respect your sovereignty to manage these disputes and so on. We want a private arbitration, which, parties must agree to, or whatever the terms might be, to settle this particular dispute. And what that does is, because it takes, firstly, the sovereignty away from countries who have the right to do these things ordinarily. Secondly, it takes away the right that countries have, particularly poor countries, to the more user-friendly and relatively inexpensive WTO system, dispute settlement sort of body, and it places it entirely in a highly unaffordable, highly charged, highly selective private arbitration process, which costs the earth and which basically just goes on forever, and it will just smoke out any small player in that sort of process. And of course, there have been notable instances of this. I'll just make 2 quick points and then stop. There have been the cases of Philip Morris in Australia on the tobacco plain packaging one, and then the Eli Lilly one against Canada, both of which I think were dismissed. That was brought under the NAFTA rules. But I think the bit of good news is that on the South African side, the South African legislation actually does not bow to that investor to state dispute settlement. It says that the jurisdiction will be within the country. And I'm not sure whether that's the final word on it, but we do have it in our law. And from that point of view, I think South Africa is relatively safe. So I'll stop there.
Thank you so much. Any last words from our panelists, because we have hit the 4:30 mark. So are there any last words regarding this issue? Andy?
No, nothing, but just to perhaps hammer again the point that we cannot sit back and say we've got a wonderful IP policy if we don't legislate. So South Africa cannot sit back with its existing Patents Act and feel that we've done enough. Thank you.
Thank you. Tahir?
I would think it's imperative for people to understand that the IP system affects all of us. Often this system is so out of view and people feel it doesn't sort of encroach on their lives. I think slowly that's becoming more and more realized, and we need to really for want of a better phrase, democratize how this entire framework works for everyone. Because at the end of the day, the customers, if you might say, are only the private actors and those that are benefiting from it. And certainly in our work, and I'm sure others, to bring this issue to the fore in people's minds is of utmost importance. And that's the only way we can really make the deeper structural changes that are needed.
It's very important, that point, Ashitai, because whatever we've learned from COVID, we need to take forward for access to other medicines and not forget the lessons once we've kind of recovered from whatever COVID has thrown at us. Professor Vada?
Yeah, just to say that, the waiver, we've talked about its shortcomings and its potential and so on. It's not a panacea, but I think it's important to continue to push back against this sort of rampant, control and monopoly that we've actually, witnessed over, well, ever since TRIPS has been in operation. So, there may not be very significant results coming out of it, but I think there'll be, it's a very important process in order to push back this sort of, unbridled march forward of monopoly. And I think that's one of the important, significant issues about the waiver.
I think a favorite African proverb is that a journey of a million miles starts with the first step, and this is probably a first step as well. So thank you all very, very much, and thank you all our participants for joining us today. Please keep a lookout for more announcements of our webinars, which are going to be a regular occurrence. I'd like to especially thank Tahir for waking up so early and joining us today, but also Fatima, who managed to slot us in her busy schedule as well. She's left for us as well. So thank you all so much, and we look forward to inviting you to our next webinar. And thank you all our panelists for joining us today, and a very stimulating discussion. Bye-bye.